Today on Law Next, the second part of what was never supposed to be a two-part interview in the first place. Back on March 12th, I was at Brigham Young University Law School in Provo, Utah, to interview David Armand, head of infrastructure and technology and senior law librarian. And we were going to talk about the emerging field of law and corpus linguistics and BYU's leading role in developing that field. But as it happened, March 12th turned out to be the very day that BYU Law School made the decision to close down and put all of its classes online. And David was very much involved in making and implementing that decision. So we ended up having a conversation about how a law school decides and prepares to shut down. We posted that part of the conversation back on March 16th in episode 66 of Law Next. And then we eventually got around to having the conversation we planned to have, which was about law and corpus linguistics. And so today we are posting the rest of that conversation, a discussion about this emerging field of law and corpus linguistics. If you have no idea what that is, well, I encourage you to stay tuned because I think you'll find it fascinating. This is Bob Ambrogi, and you're listening to Law Next, the podcast that features the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support Law Next. And now on to this interview with David, recorded March 12th in Provo. Thank you for taking some time out of what's turning out to be a busy day for you. Before we get into that, I want to talk about a couple of things, but just tell me a little bit about yourself and what you do here at the law school.
So basically, I'm responsible for anything that can break in the law school. So I do all information technology. We also do infrastructure projects, so remodeling. Most complaints for any physical plant things come through our office. And then we support conferences and courses. Pretty much everything that happens at law school, there's a piece that the infrastructure and IT area impacts. So,
well, to move on to more pedestrian matters at this point, I don't know.
We'll call
not
it
at
simpler.
all. Let's not
simpler.
Call it that.
How's that?
But, what we had planned to talk about before all this stuff happened is corpus linguistics, the work that BYU has been doing and law school has been doing around this area of law and corpus linguistics. And I know it's something that you've been intimately involved in over the last, 5-6 years now here at the school. But let's just start with some definitions here, because I'm guessing that a lot of people who are listening to this podcast have no idea what corpus linguistics even is. So let's start with a definition. What are we talking about?
Well, basically, what we're talking about is looking at a corpus or a body of text. And what we've done is we try to gather text to help understand the meaning of words within that text. It's used a lot in English as a second language. The standard case would be to get, Mark Davies at BYU is kind of one of the leaders of one method of corpus linguistics. He collects hundreds of millions of words for modern contemporary usage. And then it's easy to analyze that to say what would be, say, the most common verbs. If you want someone to be fluent in language, you can see the most common nouns that we need to know. And you could balance that through, he actually takes closed caption streams. He takes various types of media. He takes books and puts that together in a big body of text. And then you use statistical methods to analyze and parse that text to see if you can understand relationships. So the way that this helps in law is when you talk about defining terms or how terms are used. And what the proposal was, and it's actually a student of Dean Smith, Gordon Smith, who's our dean, and Associate Chief Justice Tom Lee of the Supreme Court at the time was a faculty member at the law school. And one of his students, Stephen Morrison, who had an undergraduate, he had a master's degree in linguistics before he ever came to the law school. And there was a class that they were discussing about the definition of a word, what it meant, and how the court went about doing that. And after the class, he approached and said, hey, there's another way to determine this meaning. And it should be a little bit intuitive to any of the listeners who've used the Oxford English Dictionary. It's a classic example of a dictionary that is made from a corpus. And if you look at that dictionary, it'll have definitions, but then it'll also have in-context sentences. So you can see how it's used, the different senses of the word is used in different contexts. And what the goal was with the project is to find a way that you could export this method out of a kind of a narrow niche of linguistics and import it into the practice of law to where it can inform judges and practitioners and even legal scholars of understanding how the words actually are used. And so what was used initially when we started was, again, Mark Davies. He has 2 corpuses. He has the corpus of contemporary American English, and then he has one of historical American English. And that,
just to be clear, what we're talking about here is this platform that you've put online, the Law and Corpus Linguistics platform that the law school has developed, that has several different at this point, corpuses of texts that anybody, right? It's open to anybody as of last time I checked it out.
So there's 2 different platforms. And I'll give you the history kind of the platform. So Mark Davies has, if you go to, it used to be at corpus.byu.edu. It's now at english-corpora.org. He lists all the corpora that he's grouped together on this page. So it started with his. Based on the fact that he'd just been awarded a large grant, we approached him and say, can you help us design an interface that would be better for attorneys? And could we look at areas that it could be useful to have clear definitional clarity on how words were used? And one of the areas would be the founding era of American history. And he did not have time, so we met. And it was in this room, the very room. We met for about 3 hours trying to look at the different options to see if we could include it in his, or if we'd have to build our own. And the conclusion of that meeting, based on his commitments, is that we'd build our own, and we would do our best to maintain functionality that he had articulated as a linguist that was useful for these purposes. And then we try and modernize it for attorneys that are used to interfaces like Westlaw and Lexis that have millions of dollars of development hours into it, to where it's relatively intuitive to use. And that's where BYU's Corpa, and that's under lawcorpus.byu.edu, and that's where ours started. You don't need anything other than a Gmail account. You can also just have a Google Chrome account. And the reason for that is that when we talk about these principal texts, these texts that you put together to try and answer questions about definitional meanings, you have to find where the content is. And the lawyers in the room are all excited that everything we want in the founding era is out of copyright. So we can just go ahead and grab it from wherever we found it. The librarians, those of us that are librarians in the room, had to explain that we have license agreement with companies, and the last thing we want to do is offend them or defend issues in court. So if we want to use somebody's collection, we'll need to license that. And we approached multiple vendors, but the only one that was actually easy to work with was Hein. And because they were so easy to work with and allowed us to modify slightly their data sharing agreement, we promised them that we would control how much could be exported of their content in the actual corpus, in the database that you're searching. To do that, of course, we'd have to then restrict who can log on. And then if there is someone that was using their account to try and to violate the rules of text mining, then we would be able to block someone so they couldn't get on. But we don't track what anyone does, with one exception, and I'll explain in just a second. But the acronym is COFIA, which I'm definitely not a marketing guy.
That's the Corpus of Founding Era American English.
Yeah, there you go. So it was a beautiful thought. And so those acronyms were finally killed when we got the Corpus of the Supreme Court, where someone wanted to do COSCOTUS, and the dean said, no, we'll just call it the Corpus of the Supreme Court. Yeah. But basically, COFIA is made up of 3 primary collections of sources. One that was done through years at the University of Michigan, where they took this, there's an Evans bibliography of early American imprints, and they took Evans and they contacted the different vendors who digitized the microfilm and said, your text stinks. The OCR is horrible. Anyone who's done OCR of microfilm knows how horrible it is. And they hand coded it all. They distributed this project, and BYU actually was a member of that project. So we got the benefit of about 6,000 titles, early American titles, that they'd hand coded. And there's probably a little under 4,000 of those that fit our time frame for COFIA. That was one body of text, that was free. Then we have another body of Hein text that's mostly statutes from the time period from 1760 to 1789 is the time period that was defined. And then the last source that we have is mostly founding papers that comes from the National Archives. And what we try to do is make sure that if you just want to play around with the interface, you can do it. So if you go to the interface,
Let me just stop you there, because I just want to make clear that people have a sense of what playing around with the interface would be. What's the use case? How do you use this corpus? How would a lawyer use this corpus, or why would a lawyer use this corpus? What would they be trying to do?
Well, I can tell you what people have done. So people have done things like trying to find in COFIA the definition of what officer was. That was a court case. So what they would do is they would search officer, and they would
what
look,
it was in 1780, say,
and they look at how it appears in these sources, statistically try to see words around it, to see kind of one of the early things they did that linguists giggle at because we're attorneys and we start small and then we go bigger, is there's a lot of sentiment analysis. Is this a passive or an active word? Is this an expansive definition, or is it a very particular definition, which means a lot to attorneys. And when you're arguing about vested rights, it does matter one or the other. The interface itself was designed to do that. So if you wanted to search officers, you could then use officers. You've got to be careful because, of course, this is an 18th century collection, so you have to be creative about variant spellings and using wildcards to get what you actually need. Emoluments is the other one. There is that debate about what emoluments really meant. Right,
but the platform facilitates those wildcards and variances.
Yep. So all of it's in there, and there's a help system on the side when you get there. The first thing you have to do is picture a corpus, because there's multiple corpuses there, and then what we just rolled out with the last release is you can even do a custom corpus. If you can say, I'm looking at these bodies of text, I think I'm interested as these groups use the language, and I want to analyze how they use a particular language, then you can create your own custom corpus, and it'll be saved under your Google account, and then you can run your searches based on that. And that would be the use case. Now, the simplest use case is what they're doing is looking at those concordance lines, which is the return of your search. So if you hear the podcast and want to play with it, and you want to test our servers to see how much they can take in a day, it does support asterisk truncasing as a wildcard. So you can always just go to the interface, and where you expect to enter a term, you enter an asterisk and hit return, and it will return every word in the corpus. And what it does is you can look at it in multiple different views. You could look at it in concordance lines, so you can just see them basically in sentence extracts of saying how they were used in the sentence. You can look at the frequency, which when you're using that asterisk probably makes more sense to see what the frequency of this term, how rare it was, how common it was. We just built in that frequency, there's a dispersion method, the dispersion measure that we're using that helps people understand, is this word clumped together in a few documents in the corpus, or is it spread throughout the corpus, evenly used over the corpus? And it's those different elements that then get you to a position where you can understand how the word is used at a particular time in a particular speech community. And then you can start making legal arguments about what it actually means. And so in Stephen Morrison, I think there's an article that I think was just published in University of Washington Law Review, where he explains that it's not intended to be a black box. You have to be focused on what you're trying to accomplish when you do this. But having said that, when we tried to design the interface, we tried to make it compelling enough to use that you could start getting a sense of what could do first. And then as you learn more about corpus linguistics, or read more articles about corpus linguistics, or see briefs that it's used in, you can get a sense of this is how it's done. Oh, this is a method that they're using. And so that concordance analysis is really what we saw with emoluments, and that's what we saw with officers. They also will do the parts of speech, the way that a word's used, to get a sense of whether it's used more as a noun or an adjective. Are there modifying adjectives that make this more narrow? So now we know that this have a very narrow definition, or is it just used broadly as a term? And I think that's where, for attorneys, the curve goes up in terms of difficulty, because most attorneys don't have a background in linguistics. There are a few specialists out there that do a great job. But I think that using the interface, you kind of get a sense really quickly what you can and can't do. And what we've been working on for the last year is building out the helps to give you examples. So if you're not really sure how this is supposed to work, we can give you some examples of the actual search itself. You can do the search, and then after you do the search, then you can figure out what that would mean for the issue that you're arguing. One of the tricky things that we had to do that other linguists don't have to do, I'm working on the project as a member of the bar. I understand that we have to reproduce whatever result we have. So linguists will just put together text, they'll do their research. No one has the resources to actually redo the search or see what it is. What we try to do in this interface is make sure that there's a way that you can save your results, and it will give you the date and time, it'll give you the actual search that you did, it'll give you what your results were. So that way, if you're recording in a brief, you can actually cite to it. And we worked for about 2 years trying to, how can we do this? Because we know the underlying data changes. Is if we fix OCR errors, which I was committed not to do at the beginning of the project, but we're doing as we speak. If we get a new source to put in it to broaden that speech community that we're covering, how do you prevent me, who did my research last year and now we're on appeal 4 years ago, how can I say that this is really what it was? The way that we do that now is by using actually Google Sheets, which I'm grateful that they're free, and the size is not limited. But what we can do is you can actually save your results to Sheets. We save a copy, which gives you a permanent URL. We don't view that copy, but you have the URL. You can't edit it. It's a non-editable link, but you can download it and do post-processing if you want to.
Yeah.
But we figured this way, you can include that handle in anything that you file with a court, and then that court can follow it. And until Google goes away, which some people hope may be soon, but I expect will be later, then at least you'll be able to reduplicate whatever research you're doing.
Have you ever worked with the PermaCC people at Harvard about?
Yeah, we looked at it. We were trying to find a way to simplify it for researchers rather than having to take that extra step.
Yeah.
But that would have been one of our biggest concern was how can we communicate in the interface that something happened? And what we found is that Google Sheets now has this, in the Google Sheets API, we can actually give you the percentage of what's downloading, because you can download up to 100,000 concordance lines. So if you do that asterisk search, you can only do 100,000. There's more lines than that, but you can do 100,000 of those. And then you could do it's a statistical sample it's taking whenever you make, they're called seeds when you do your search. And so you can do multiple 100,000 downloads if you want to. But in doing that, it does take time. And we knew people would start clicking out of the interface and just redoing the search and tying up server assets. So now your Google Sheets will open and you'll see in the first cell, it'll tell you what your percentage, and then your tabs will tell you what each result is based on what your search was. So
yeah, I know I've played around with this a number of times. I know the first time Dean Smith, who's the dean, Gordon Smith, who's the dean here at BYU Law School, gave me a demo of it. I think it was when there was a case pending at the Supreme Court involving the Second Amendment. And he uses an example of, what does the phrase bear arms mean? Or what did it mean, to the drafters of this language when the amendment was written? And it's kind of fascinating to go back and do the analysis and look. It really helps put things in perspective and shifts your understanding a little bit, possibly, or helps shape your understanding anyway of what it meant. Well,
for us, that was a good moment for the people that worked on the project, because in some ways we were tied really strictly to this public meaning originalism. We're trying to come up with a public meaning of the world, which is a group of scholars that are specifically interested in a certain area, which is narrow. It's really narrow. But when that came out, it was interesting because we were kind of cabined as these conservative. BYU is a conservative school. They're trying to do this, but the interface is really ecumenical. It doesn't have any particular bias. One underlying text that we're searching in the bottom, which if anyone thinks that we have time to figure out what document put in there to affect someone's search, man, I would love to have that much time, but I couldn't imagine anyone that have that much time to figure it out. But in this case, it's an example where what came out is that people were very critical of Justice Scalia's conclusion, saying, wait a second, no, we don't find any cases in here where it's talking about personal firearms use. Bearing arms is just not a term that was usually used with anything other than the militia. Now, again, this is the fun thing about, we just finished our 5th annual conference of law and corpus linguistics that Dean Smith started the inaugural conference, and we have a very famous linguist, Stefan Negris, who's at UC Santa Barbara. And talking to a linguist, it's always funny. They're always a little bit afraid of Stefan because his specialty is statistics applications. He's an amazing social scientist. And again, the goal of this is to make sure that you can set up a set of records to defend a falsifiable thesis. We believe that bear arms means what people did when they hunted, right? So that's not a good thesis. I'm not a linguist. That's all disclaimers apply.
Yeah, right.
But then you can actually do search in it, and we can say, no, that thesis doesn't work, and here are results. And what he explained in the conference is that we're never going to say that it's definitive,
right,
because it's science. We're always learning more. But what we are going to say is it's repeatable. And based on the parameters that were given, you will get this result every time. And I think that that's where the debate comes, even with the Second Amendment case. Someone will say, well, we want more of this type of speech in there. Well, when you're dealing with the 18th century, if you want the speech between drinking buddies after the militia of how they refer to bearing their arms to shoot bunnies, right, doesn't exist anymore.
Yeah.
And so we can't scientifically study that. There's still room for someone to make their argument to say that, based on John Adams' diary, this is how it should. But based on the text bodies that we've put together, scientifically, all we can say is that we can't support this particular explanation or definition of the word.
This platform has been used. I know Justice Thomas at least cited it in a footnote once or something in the Supreme Court. And the Utah Supreme Court, I know, has used it on occasion.
And I think that even more than us is Mark Davies. So COCA has been used several times, I think, by the Michigan court. I can't remember if I think Ohio may have had an opinion this year. And I'm sorry, Gene Smith would keep up on the scholarship. I do the care and feeding. But
Mark is the lawyer who's doing.
Mark is the linguist at BYU.
The linguist. Okay.
Mark Davies.
There's a lawyer who's essentially made this his practice.
Yeah,
right?
James Halpern is the one
James
that actually.
Halpern,
he has a group of. I think he has a nonprofit that he's running right now that'll help people kind of analyze, and he's been really instrumental. He was here as a visiting faculty, I guess a visiting scholar for 2 years, and Stephen Morrison, who was the student actually who wrote the first law review article arguing for its use and was just recently published. He's, I think, a teaching fellow at University of Chicago this year. He's another one that has used it in practice. And there, it's his most recent article, I think, is talking about where it fits in contractual terms. Right. In terms of...
It's contract interpretation with Corpus Linguistics, 94 Washington Law Review, 1337.
There you go.
I got it in front of me. October 31st, 2019, it was posted on their site. I can put the URL on the show notes.
Just fly through those 82 pages. So I don't know. But it's a great positioning statement. And this is what, when we first started, this is one of the challenges with academic legal tech. And I don't know, you do legal tech more broadly, and it may be always kind of a challenge between putting the cart before the horse. But we're trying to define an interface, and define's probably better than design, but we're trying to design an interface that practitioners and judges and scholars can use, but the use cases aren't fully defined. We have some fuzzy cases, but we know no one's even going to try and establish that as a method without having something out there you can kick the tires on. So we want to build a car, but we don't know what anyone's going to actually do with it. So this article with Stephen is fantastic because it actually says, here's some situations where it makes sense to use it. Here's some situations that it probably doesn't make sense to use it. And I think that as that emerges as a discipline, then I think it'll percolate through the practice of law. And then we may have to alter the interface. That's the biggest change in the last years. We've had Brett Hashimoto, who's a linguist from Northern Arizona, who's just finished his dissertation. So he's been here as a scholar in residence for the year. And the interface team loves the definitiveness which he can answer our questions, but as kind of the team leader of the project, it terrifies me how many times we may have to backtrack because we may not have understood something as well as we thought as attorneys and developers, as opposed to a linguist. But I think it's been healthy, and I think this conference was fantastic to have that balance between the linguistics community and the legal academic community, and I think that hopefully that will inform how practitioners use it. Yeah.
And I mean, it sounds like you're saying, I mean, when you talk about it, it sounds very academic and it sounds very scholarly and it sounds like something that might be, in legal setting be of interest to, appellate judges or an appellate argument. But from what I'm hearing you say now, there are applications for it well, you're still trying to figure out, but there are applications for practicing lawyers today. It's not just about, what did the founders mean when they put this word in the Constitution or something. There are applications for using this in law practice in the contemporary world. Yeah,
absolutely. And I think that what we're trying to do is the interface is a good way to learn the terminology and some of the theory behind it. And then if you're there was a case that the Supreme Court didn't have to reach the corpus linguistics analysis, but just in our own city in Provo, the Provo City's Council actually made a corpus linguistics argument about the definitional term of a statute. And I think that those arguments can be made. And I think as the bench is more comfortable analyzing and as attorneys are more comfortable with where it fits into their practice, I think you'll see it used quite a bit. But I think our interface, Law Corpus, the advantage that we have is we're assuming that you don't have a high degree of sophistication other than that you're probably legal trained, and that you have a high expectation for a functional interface and helps that will kind of help you on your way. And I think we're working on things like video helps. Gordon has kind of let out on some executive training that we're trying to get some people certified in using the method, or if not certified, at least very comfortable on two directions. You may decide that this issue is so complicated that you're never going to be qualified as an attorney to do it, and you'd hire a firm like James Halpern's firm or another firm to help you with this. But on the other side, if you're seeing someone making these arguments, we want to make sure that you know how to evaluate them and say, well, what was that corpus made of? And is the speech community that you're representing really representative of who the statute should be speaking to? And are your legal arguments based on your evidence, they supported, or are you stretching based on the fact that it looks like a numbers thing, right? It's science, and so you just have to believe me. So I think that this is all, as it unfolds after 5 years of trying to kind of get this moving, isn't a whole lot of time. When Gordon came to me and said, how long would it take to build it? And I told him 5 years. I think he thought I was crazy. But those of your listeners that do legal tech, it's really great to believe that we can throw everything together in 6 months. And we did have an interface up within a year, but it's almost functional at the level that we're still technically in a public beta. This is our fourth version of a public beta. And next year we will actually have the actual product release, which will be probably almost identical to what we're doing now. So
yeah. We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview. Here at BYU, you've got this platform. You just been doing the conference for 5 years in a row. We're here in March 2020. You had the conference in February, as I understand it. You're starting to do some training. You mentioned executive training. And I think you also do training of judges as well.
Yeah, James Halpern has actually been pretty active. And I can't remember what his goal is, how many circuits he was trying to ride, and cover it. But so there's probably 15 or 20 that they have. And then Associate Chief Justice Tom Lee has actually spoken multiple times at multiple schools. And I think
he's written about it too as well.
Yeah, no, and he's under contract. I think there's a book coming out from Oxford on it with a few of them as well. So
yeah. So is this something that's an academic discipline that's getting picked up by other law schools, or is it pretty much all centered here at BYU right now?
Well, I think it's definitely not. It was originally all centered at BYU, but I think it's definitely not just an academic thing, and I don't think it's just centered at BYU. I think that...
No, I didn't mean to suggest it's just an academic thing, but I mean, as an academic thing, is it?
I used to practice law, right? I like it when it's just an academic thing. It's easier. So well, I guess someone could get me for malpractice someday. I don't teach anymore, so I don't worry as much about educational malpractice. But there are some schools, mostly linguistic schools, that are actually now developing more capacity in the legal area. And they're really kind of pushing the envelope of what you should and shouldn't be trying to do using this method. And they're also introducing other methods of linguistics that would be helpful, again, for understanding meaning. And there's a whole host of any type of interpretation issue. Linguistics can really help. We presented Sean Nevers, who's our director here at the law school, and I presented at the Harvard, the Case Law Access Project. They have a working group that met. And most of the people there were doing machine learning on the text to do some historical analysis. But we presented there, and it was amazing to hear how many people said, yeah, this is actually one of the things that we wanted to look at. So I think that you'll start seeing other schools that have ability with linguists doing similar sorts of analysis. And I think that the way that it looks like it's being positioned in academia is that it looks like it may be positioned in kind of a type of textualism. And I think that what we'll see probably in the next 5 or 10 years, as more schools, BYU's at the early stage of this, we're trying to develop a lot better support for analytic projects from faculty. So many faculty are coming with a PhD in economics or some other social science. And typically the IT staff, we kept things running. We weren't forward looking, but we're actually looking at expanding and having equivalents of like a data science operation in the IT department. But I think actually what we'll find is that this linguistics analysis fits fairly well with other big data approaches. It's not, we like to call it big data. I mean, it's a great way to market it, but big data is much bigger than what our corpus is. Yeah. But I think that those language approaches, they're cross-fertilizing. So I think that we'll get to a stage where you'll see people that will do hand in hand. And that's when I think what you'll see is an attorney that's looking for an argument about defining the word. They might look at the case law. They might look at a dictionary definition. If they have a really nice library to go to, they can look at OED and see concordance line and kind of different use communities, how it's used. But I think I wouldn't be surprised if in another 5 or 10 years that it's just common that you use it. My dream as the interface designer is that we could talk the big database vendors like a Westlaw, Lexis, Bloomberg, these people to implement it into their interface because they have much bigger bodies of text than I do. It's easier for them, but no offers have come yet. But anytime they're interested, we'd love to talk. So
sounds good. David, we are just about out of time. Is there anything else that you wanted to mention about this before we
No, I think only to encourage people to play around with it. So and complain. We have a feedback form, and this is how primitive you are in academia, right? So it goes to a Trello board. So that's so we can see whenever we do our interface meetings. So that's the other thing that's been kind of amazing about this project is that there's really no full-time people ever devoted to this. I have multiple day jobs. I cover, as far as I can tell, about 2 full-time other jobs. And then all our interface designers are actually used people that have full-time jobs that are just mostly working in the evenings and nights, weekends. We get away sometimes with lunch meetings. And so, but in those lunch meetings, we review how many requests we have for bug fixes, and we just don't get a lot of feedback. So if you see things, feel free to give us feedback. It's still an ongoing project, and we're hoping to have it in the type of shape that everyone can use it by really the early part of next year.
And a reminder that you can find that at lawcorpus.byu.edu. We've been speaking with David Arman, Head of Infrastructure and Technology at BYU Law School, here live in Provo, Utah, where it's always a beautiful place to be. I love it here. Thanks a lot, David. Nice to talk to you.
It was a privilege, Bob. Thanks.
And before I wrap up, let me just once again thank the sponsor who made today's show possible, MyCase. With thousands of customers, is a trusted practice management solution helping lawyers across the country run organized, efficient, and successful law firms. Try MyCase for free today at mycase.com. And as always, a big thanks to Ben Ambrogi for producing and editing the show. That's it for this week. This is Bob Ambrogi.